Hey there, Angel. Thank you so much for joining me. It's good to see you again. Maybe just give a brief introduction of who you are and what you do to our audience.
Thank you for having me again. My name is Angel Saunders, and I am an estate planning, trust admin, and probate attorney with Hopkins and Carley in our family wealth and taxation department. Joe and I are going to be talking a little bit about what we both do for work and how sometimes our paths cross in terms of clients and trust admin.
A lot of people, shy away from talking about things like money, things like death. Even though they're very important things, a lot of people will leave those things off because it's uncomfortable, it's stressful, it's difficult to talk about those things. But unfortunately, we have to, right? We have to talk about those things. We have to focus on what we're going to do with our assets, with our things, with our homes, with our liabilities, with everything when it comes time where we're not able to take care of ourselves or we pass away. And if we have beneficiaries, if we have children, grandchildren, charities, and loved ones, et cetera, friends that we'd like to leave our things to, we need to plan for the inevitable that we're all going to be incapacitated and or pass away. I think it's important that we start just kind of talking about maybe a little bit of the basics. You mentioned to me over the phone, you had a story or you have maybe like a common situation that occurs with you that I also see commonly as somebody who works on a lot of probate and trust sales. Would love to just have you kind of jump in and tell us about that.
So I have many stories, but a common thread that I can probably share during this call and what we discussed earlier this week is, fundamentally, there are folks that never have an estate plan, whether or not they talk about it, around the dinner table or not, they just somehow never get to it in terms of putting words on paper, hiring an attorney, and getting things properly in order. That is an issue itself, right? For folks, like you said, that, never have an estate plan or don't think about getting one, the reality is that we should. I said this for years, is that really for anybody in California, and I imagine all states, it would be the same, but because I practice in California, I'll mention California, is once you turn the age of 18, technically you need powers of attorney and advanced healthcare directive at a minimum, right? Even if your assets are at a negative because you have a bunch of student loan, you are by law a legal adult. And so at a minimum, you should consider having an estate plan that is equivalent to powers of attorney and advanced healthcare directive so that your parents, your next of kin can make those important decisions for you. God forbid something happens to you when you're away in college or traveling or whatever life circumstances. Of course, as we get, older in life, where we have a business, where we have income, where we have a home and also children, then estate planning becomes even more of an important issue for people to not just talk about, but to implement. A part of my job is I sort of see myself as a gatekeeper toward probate, yes, from a legal standpoint, but also somebody that offers clients a peace of mind so that, okay, if I'm traveling, God forbid something happens, I have a document saying, okay, who's going to look after my children? I have a document that's not going to put my spouse or my kids in probate. And really what probate does, and what I witness every time, is that probate, essentially the folks that are left to grieve are robbed of that time and that opportunity, because instead of taking time to grieve the person's death, they're having to deal with all the legalities, because the banks froze the account, they don't have access to the title or whatever issues there might be. So not having an estate plan, that's one problem and one issue in of itself. And the other one, which we spoke about the other day on the phone, is stale estate plans. When I say stale estate plans, what I mean is estate plans, and in my definition, is any estate plan that a person signed that he or she or they have not picked up in, let's say, 10 years. And 10 years is even kind of pushing it. And I say that because our tax laws change with every presidency, and our tax laws change depending on the flow of Congress, right? And this is especially true and relevant for our high net worth clients. This past week, I got a call from a friend. He was asking about a family member, or rather for a family member who had a trust drafted probably 15 to 20 years ago. And there's provisions in there that do not complement her life right now and really just should be looked at and should be revisited because her life circumstances and the people around her have changed. Relationships have changed in the last 20 years. And, unfortunately, a lot of times with these situations, once you wait past a certain period, a lot of our elderly clients, if you don't want to think about this stuff when you're 40, you probably definitely don't want to think about it, or most of them don't want to think about it when they're 80. They just want to live in peace. They want harmony. They want their family to like them. They want their family to approve of them. And then there's also the issue of capacity, right? Do you have capacity to talk about your wishes and to make a sound decision that, your attorney would be comfortable working with you and wouldn't be afraid that, they're working with somebody that may not understand their trust or the changes they're trying to implement. That's a huge issue in my world. And frankly, not just my friend calling me this week. I got another referral from, a fellow attorney, very similar circumstances where it's sort of coming down to the wire in terms of timing. And most of it all centers around, just I meant to, but 10 years went by. I meant to, but I didn't have time. I meant to, but I just couldn't, sort of step on it and really get moving on that particular decision. So, not having an estate plan or having an estate plan that's been unreviewed and untouched for a number of years can be a huge problem for the family members, right? For the individual themselves, yes, it can come up as a problem if they're incapacitated and they have nominated someone in their documents who, let's say, are deceased or are out of the country or are estranged with them, right? Or have no idea what they do on a day-to-day basis. I mean, that's a problem for the individuals themselves. Post-death, if you have a stale trust, it could pose, issues for family. And that sometimes can lead, unfortunately, to trust litigation.
Like, for example, one that I've seen is somebody put together a trust maybe 20, 25 years ago. They had the trust, person passed away. They named a successor trustee. And then lo and behold, the biggest asset, the property, is no longer in the trust because maybe they refinanced the home, had to take it out of the trust for the lender, took it out of the trust, and they never put it back in. They forgot to sign the paperwork or make that happen. The other examples that you mentioned as well, that maybe the named successor trustees, maybe one of them unexpectedly passed away. Maybe the other person is the second successor trustee is estranged. Maybe there are new beneficiaries, new grandchildren that are born now that aren't named in this trust. Maybe, talk to some, real world examples and maybe some other things that you've seen. What can go wrong if you haven't updated your trust in a while?
So the first one you mentioned, luckily it's becoming less and less frequent because, lenders and title companies are luckily becoming a little bit more, I would say, considerate and responsible in terms of, if you're going to ask a customer to take their home out of their trust for lending purposes, somebody should also prepare a deed, which takes title company 10 minutes to then put the property back into the trust. I would say early on in my career, I saw a handful of those. And, very innocent mistake, mom and dad or mom, refinanced 20 years ago. They had their property in trust. They took it out of the trust and then never put it back in. Fast forward 20 years, both of them pass away and it's subject to probate. Luckily in California, we had a streamlined process for that via what's called a Hague step petition and, makes the process a little faster. So the, family there, they don't have to go through a full blown probate year and a half process to capture that property within the trust. It's still going to cost you probably a few $1,000s at a minimum in attorney's fees, but at least, we take away the factor of time, right? Especially if they're trying to sell, they're trying to clean the house, they're trying to, do the trust administration. Real life examples, right now, being with Hopkins and Carley, I work with a lot of large size estates. And so one that I do come across, 30, 40% of the time, so not too much in frequency, thankfully, is we have two spouses and they're relatively high net worth. And they have a trust that was drafted, let's say, in the 80s. And most trusts that were drafted in the 80s have the ABC provision, right? Or at least the AB provision. And what that means is upon the first death, the trustee, aka surviving spouse, is supposed to allocate the totality of the trust assets into various trusts. This is required by the document itself because husband and wife both agree to it. And what you come to find is first spouse dies and the surviving spouse does nothing. They may not even remember that they have a trust, or they know that they have a trust and think that, okay, it's okay. We have one. We have one drafted. I don't need to look at it again. The kids are grown. They're fine. They're going to get everything when I die. So I'm going to leave it. And what happens is when the second spouse passes away, the kids bring me the documents and I have to then go into the process of explaining to them. So there is, sort of this myth that mom or dad didn't do when the first spouse died. And so now you, child, as a successor trustee, you have to make a decision. And it's a decision that if audited, the IRS is going to look into too and ask is, this wasn't done, this ABC funding or AB funding wasn't done when mom or dad died. So what do we do now? Do we go back in time and fund it? Or do we not and treat that decision made by mom and dad as, a decision to which the assets are includable in the second spouse's death? And that can be a really stressful and complicated decision for family members. Because then I also explain to them, hey, trustee, by the way, you're signing under penalty of perjury. And so if you're audited, you're going to have to go and sort of explain this to the IRS. Those things, I think a lot of lay people that, aren't around CPAs and attorneys, they don't think about because they just think, oh, I did my trust, so I'm good. And that's, partially true with anything in life, right? Be it your health, your car, your house, there's some sort of maintenance that you have to keep up with. And so, for our clients that have taxable estates, that's, definitely something that comes up. Probably the general issues that I see when it comes to people that, don't look at their estate plan for a long period of time is definitely, just beneficiaries or trustees that they really later in time don't think it's a good idea because somebody has aged out, because, the kids are grown, or because this person is no longer in their life, or maybe the charity they're no longer taking interest in, what have you. So those are all probably real, your everyday issues that come up with people that don't revisit their estate plan. And this also translates to advanced healthcare directives, right? If you're a married couple, your husband or wife is usually the first agent, and that's fine. But then, what about your second agent, third agent, or fourth agent in the event your spouse isn't around?
How often would you recommend somebody, the average person revisits their trust and meets with an attorney and looks at everything and updates things? How often would you say is best?
At least 4 years, especially for those that, just from a tax standpoint, if your estate is taxable, it's always a good idea to just look at it, review it, and make sure things are in order. And even if your estate is not taxable, it's just a good idea to pull out your documents and know, okay, this is who's going to potentially pull the plug on me. This is who is going to manage my funds. This is who's going to do this, right? And it's also a way for clients to ensure that their assets are properly funded under the trust. And what I mean by that, and this too, is, the title of your home is in the trust. If you bought another property, you didn't forget to put it under the trust. You open up another Chase account, you open up another Schwab or what have you, those accounts are under the name and protected under the name of the trust. The only way you can, not the only way, but one of the ways you can do that is to pull out your documents and look at them, spend half an hour with yourself, your partner, your financial advisor, and just make sure that everything is in order.
Say there's a minimum amount of assets. Like, if somebody says, well, hey, Angel, I've been renting, I rent, I don't have a lot of money. I have a 401k that maybe has $80,000 in it, a few other, in a car and a few other things. What is a minimum amount, I guess, of value of assets should somebody start thinking about and doing estate planning for?
Well, the threshold for probate in California is, I I didn't look at the number recently because a lot of our clients are high net worth, so it doesn't apply. But I think that the threshold for probate in California is about $180,000, which means like just use me as an example. If I got hit by a bus today and I have, 200 grand in some account and that account is not sheltered under a trust, then that would be subject to probate. And so it's a pretty, relative to the wealth that's in the Bay Area, it's a relatively low amount. And so, anybody with assets that are above that value should really consider an estate plan. And a common misconception is a lot of people think, oh, if I have a will, that's sufficient. And that's not true. A will does not mitigate probate. A will simply tells the judge who's looking over your probate case where you want things to go. Only a trust can mitigate probate. And even then, you have to make sure that your assets are properly funded under the trust. And really, anyone that hires an attorney that does what I do, in various sort of levels, will be able to advise the client on these basic parameters and requirements. It's the ones that, kind of go online and do it themselves through LegalZoom that they perhaps sometimes risk missing these important sort of requirements, to having a proper estate plan.
So last time we spoke, we talked about a Prop 19, and obviously that was a major shift and caused a lot of people to have to get in there and update their estate plans based on the timeline and deadline of that going into effect. Has anything recently come about or coming soon in the legal landscape that might cause people to need to go in and update their estate plans soon?
Nothing new that I know of, and I have not heard. Perhaps there are groups actively working to try to get a new proposition up there in the next coming years. I imagine there must be. I don't know anything that's in the works that would undo what Prop 19 did. When that happened, it was quite a frenzy for a lot of our clients, particularly those that, let's say, their home and one investment property is their wealth. Right. And we have a lot of clients within different cultural backgrounds that, maybe don't have a large investment account. They just have their primary home and an investment property. And their goal was, okay, I'm going to, keep these. And then when I pass away, my kids are going to get that. And that's going to be my sort of gift, my legacy to pass on to my client. Prop 19 kind of shifted that because, of course, now with Prop 19, if you are a child inheriting investment property, unless you can afford the, full reassessment and property taxes, you're really not going to be able to keep the home. Then, I, have the discussion with clients, when they're sort of in that, what do I do? What do I do is, don't let the tax tail wag the dog. Yes, having to pay the county property taxes. I just paid mine, and it never fails to make me feel not pleasant, even though I write the same checks every year. But, Congress has not gotten rid of the step up in basis. If you hang on to property in this country at the time of your death, the value has a full step up. And so maybe your children can't inherit the property in physical form, but they can inherit the property, they can sell it, and they can hopefully, with that step up in basis, pay little or no capital gain. And so they still get to walk away, in this area, depending on where you live, right? If you have investment property in Palo Alto, you're still going to get a pretty nice inheritance. Yes, Prop 19 did change the landscape quite a lot, but we still have the capital gains basis for clients to, kind of look to ensure that, or maybe have sort of a sense of comfort that their kids are still going to get something.
Thank you so much, Angel. I know we're past our time a little bit here. Would you please tell us a little bit about which areas you work and what the best way is to contact you? What is your ideal client? What are you specializing in? And what is the best way for somebody who just watched this whole video to say, hey, I'd like to work with her and I'd like to reach out. How do I make that happen?
I work in the realm of estate planning, trust administration, and probate on a case-by-case basis. I would say a lot of my day is in the planning arena. That starts with your basic foundation of a revocable plan. And that's what I think commonly we all know. That's the living trust or revocable trust. That's the will, powers of attorney, and so forth. So at a minimum, all my clients, they start there. And depending on the size of the estate, I also talk to clients about various tax planning tools, or AKA irrevocable trust, that they can set up, particularly now because the current exemption per person is about 13 million and it's supposed to sunset in 2026. It could change depending on what Congress does, depending on the next election and how that goes. So particularly for clients that are high net worth that, have not talked to an attorney, a CPA, or a financial advisor about possibly using their exemption right now, this would be a great time to talk to somebody like me about that. And the best way to reach me would be via email, because I'm not always by my phone. And so via email, it would be Saunders, and A as in Apple, Saunders is SAUNDERS at Hopkins Carley, and Carley is CARLEY. So Saunders at hopkinscarley.com.
And we'll make sure that we have that contact information in the description of wherever this video is being watched. Thanks again, Angel. Always a pleasure. I appreciate it.
Yeah, thanks, Joe.